My name is Mary Bonnema. I'm a partner in the Intellectual Property Practice Group at Warner Norcross and Judd, and we're going to talk about why intellectual property is important in the cannabis industry. Just like other companies, Michigan cannabis companies sell services like cultivating, growing, and wholesaling cannabis, and products like flower, pre-rolls, and edibles. Those products and services are bundled with intellectual property rights that really should be protected and enforced. Intellectual property that's well protected adds value to the bottom line of your business, and in short, you can make money on your IP. So what is intellectual property? Well, like a house is real property, intellectual property is property of the intellect. It's property of your mind. Intellectual property are legal assets that protect the fruit of your creative genius. And there's a variety of types of intellectual property: patents, trademarks, trade secrets, trade dress, copyrights, just to name a few. But today we're going to focus on trademarks in cannabis. Trademarks are brand names that travel along with your products and services. Think of Coke for soda or Nike for shoes. We're going to focus on three specific areas of trademarks in particular: selection, searching, and registration at both the state and the federal level. Trademark selection is critically important because not every term that you use with your products is going to be a protectable trademark. So it's really important that you follow a couple of key rules. One is pick a good trademark, one that is unique, creative, distinctive. This means avoiding using ordinary or slang cannabis terms. You should also pick one that no one else is using so you don't step on another's trademark toes. Selecting trademarks is an art. It requires creativity. A good, unique mark plays both offense and defense in the commercial marketplace, and it helps you create and maintain a strong market presence. So let's talk about trademark searching and why it's important. Trademark rights in the United States arise out of your use of a mark, not its registration. So you have a legal obligation not to step on another's trademark toes. You also want to avoid getting a nasty grammar lawsuit for infringement. But trademark searching is quite difficult in the cannabis field. So why is it hard? We naturally want to use the same terminology in this field, such as pot or green or relief. So trademark names are bumping into each other. We also want to use descriptors so it's easy to market goods, but the term might not create trademark protection. Searching is also difficult because many companies are not easy to find on trademark databases, and so many products must be considered in a trademark search. So when we're doing a trademark search, what are the couple things that we're looking for? We're looking to see if the marks are confusingly similar in sight, sound, and meaning with another prior trademark in the marketplace. We're also considering whether the goods are related. There's many factors, but whether the marks are confusingly similar and the goods are related are really two good factors for a gut check. But it is a complex legal analysis that isn't intuitive, so really get your trademark lawyer involved. Let's talk about trademark registration, which really is in a state of flux. We'll talk about Michigan trademark registration at the state level and U.S. trademark registration at the federal level. You can obtain a state registration for authorized cannabis goods and services that are in use if the mark is available for use and registration. But those rights will be limited to the geographical area in which you're using that trademark. Currently, under Michigan law, you cannot register company names, trade names, or assumed names as trademarks in Michigan. But again, this is in a state of flux. U.S. trademark registrations are very helpful because they nationalize the scope of your trademark rights. Unfortunately, you cannot obtain a U.S. registration for cannabis because cannabis is unlawful under federal law. But you can with a couple of exceptions. You can obtain a U.S. trademark registration for lawful sister goods and services such as cigarette refill cartridges, or lighters, tobacco tins, clothing, rolling papers, or educational or informational services. You can also obtain a U.S. registration for industrial hemp products with less than 0.3% THC. U.S. registration is very helpful because it provides a great foundation for expanding into other territories, particularly as cannabis becomes legal in other states. At the end of the day, trademark registration is a process. It isn't guaranteed. Hurdles may exist. It does require patience, and it's an investment, not just an expense.